Welcome back, everyone. And it's now time to start our final topic for discussion. We're going to hear from both Davida and Howard and some information related to child support. So not sure which one of you plans to start, but feel free to kick it off.
I think I'm supposed to, I believe I'm supposed to start.
Yeah.
Am I on?
I understand.
Okay. All right. So just in case you guys saw some animals walking around my screen, I just wanted to apologize that my two elderly Persian cats actually jumped 4 feet onto the dining room table. So I apologize. So Howard left off at a really important topic that I like to explore just a little bit in context of child support, and that's the issue of shared parenting. And I just wanted to say out here in the eastern counties, and Howard, please correct me if I'm wrong about Ashtabula, but from my experience, shared parenting is preferred out, at least here in the East, and likely this seems to be a trend throughout the country. And the reason that shared parenting is preferred is that basically the science demonstrates that children actually do better when they have a relationship with both of their parents. They do better physically, medically, academically, socially, emotionally, in every respect. Children do better when they have a relationship with both their parents. I think what is a little bit different about legal aid, though, is all of our clients are survivors of domestic violence. So that actually, it makes it a little bit different from the general preference for shared parenting. But I would say that in my practice, more than half of the parents do get shared parenting. I don't know if that's true with you too, Howard, but I would say that even though there is domestic violence in the cases, shared parenting is preferred by the courts. So that being said, I want to talk a little bit of why is there child support and talk a little bit about the new law. And I'm going to do my very best to be objective about the new law, but I'm just going to say that it's going to be hard for me to be really objective because for 30 years I've represented usually the custodial parent in these cases, and they're low-income people, so they really need child support. So like I said, I'm going to try to be objective, talk about the pros and cons of the new law. So why is there child support at all? The purpose of child support is to ensure that children receive the basic necessities such as food, clothing, and medical care. And for low-income people, next to earnings, child support is the second largest income source for low-income families. And on average, sometimes with low-income families, child support is almost half of the income for that family. So that's why we have child support. We have child support to assist children with their basic necessities. Another reason, and I don't think this is the reason for the enactment of child support, but we just know this from the research, is that child support actually usually strengthens families. And according to the National Conference of State Legislators, child support strengthens families, and about one half of all children in America spend spend time in a single parent family. And the non-custodial parent who pays child support is more likely to remain involved in that child's life. And the studies show a positive correlation between the amount of child support and that the non-custodial parent pays and the children's behavior and their school achievement. So recently, there was new legislation, and the new legislation was House Bill 366, and it was enacted on March 28th, 2019. So we're all getting used to the new legislation. And one of the outcomes, though, of the new legislation, which you wouldn't necessarily expect, is that child support orders are actually lower than they were for, than the child support orders that have been in effect since 1992. And so just to kind of give you an idea of what that means. So I actually have been practicing law for 30 years now. So around November 4th of 1990, that's when I passed the bar. And it was really just a year after I passed the bar that what we called then, 30 years ago, the new legislation was passed. And it was passed on an income shares model, which really was a model where the income of both parents would be considered, and that they would try to affect child support so that the child's lifestyle did not change just because the parents separated. And that was the model from basically 1992 until 2019. So for that entire period of time, there was the same child support table. So there was like no increase in child support during that more than 25-year period. And it was based on the number of children, sometimes the cost of daycare, health insurance, and they would put into a child support calculator based on those kind of factors. Now, well, let's talk about what is good about the new child support law. So there has been a real movement, I would say, with respect to how much child support can be a hardship on low-income obligors, or the people who owe child support. So what has happened is there always was what's called kind of a reserve that used to protect low-income obligors for not having to pay so much child support that it affected their ability to support themselves. But the new child support law of 2019 makes it so that if you make $14,000 or less per year, then you will pay the minimum of about $80 a month in child support. Some other changes, and this kind of goes along with what I opened with respect to shared parenting. If you have parenting time and you're the non-custodial parent and you have over 90 overnights during the year, then that will mean that you will get a 10% deduction on your child support. And then also, if you have shared parenting that is equal in time, like the very common model that is basically the 2-2-3 model, which means 2 days with one parent, 2 days with the other parent, and then alternating the weekends. Then, so if you have that kind of 50-50 shared parenting, that there must be a significant deviation downward besides the automatic 10% deduction, and that must occur, or the court would have to put in a written findings and explanation for why they did not order a substantial deviation downward. So what is the impact of the new House bill? So like I said, one of the things that I represent low-income custodial parents for the most part. So why is child support so necessary in the role of low-income people? Well, poverty affects a child's development. And so poverty can disturb the child's brain development if they don't have adequate nutrition. And if you look at the state of Ohio, and you wouldn't expect this because, we're an agricultural state, right? But as of 2015, Ohio was ranked 6th in the nation for food insecurity. And 1 in 4 children in Ohio have that kind of hunger. And what are some of the other effects? I'm sure many of you, as I understand it, are social workers. So to me, the number one problem that I have with my clients that is not a legal problem, and as I said, we try to work holistically with our clients, is housing, especially out in Lake Geogga and Ashtabula. Affordable housing, especially subsidized housing, it's the number one issue that I have representing my clients. So if in fact you receive child support, that child support goes a long way to paying that rent. Many times you can have some food stamps, so that's where you handle the other very important monthly expense, food. So, and those are two likely some of the most important factors with our clients. And also with respect to, and some of you who are still have parents, some of you who are parents and paying daycare costs, we all know that daycare is super expensive. And so, not having child support, or having very low child support and having to work, having to pay daycare, having to rent an appropriate space, and keeping into account that when you, let's say you stay home, you have 2, 3, 4 children, you're out of the workplace, then it's more difficult for you to earn a living wage where you can support yourself and your children. Let's see if so I just wanted to talk about the terms just a minute. I'm not sure, I'll try to answer the chats maybe at the end. We'll just get through a couple of points. So the person who is the obligor, the child support obligor who owes the money to the residential parent. And then the other term that you want to know is the obligee. That is the custodial parent who receives the child support. So in thinking about what the courts were trying to do in this, I believe that the policy behind the new child support laws was a more fair opportunity for the non-custodial parent to get credit for when he does see the child or she sees the child, and when that there are additional expenses for the non-custodial parent, just like the custodial parent. So if you're going to have your children 2, 3 days a week in a shared parenting plan or half the time, then you're going to need to rent that bigger apartment or that home. You're going to need to have more, be able to provide internet so the children can do their homework at your home. So just, kind of recognizing what's going on with the modern family and making it more feasible for children and for both children to have a more comfortable life. So these are just some of the pros and cons of the new law. Like I said, it's hard for me to understand as an advocate for low-income parents how the child support didn't go up in 25 years, because when you think about how much more rent is, how much more groceries are, that now you do have to have a computer. Now you do have to have internet, to help your children in school, and just the various costs. It's been very difficult for especially low-income women, I'll just say, just because of the salary inequality, and also for many of our clients just being out of the workplace and not going to school, not keeping their career on a on a forward path. So those are just some of the thoughts that I had about the new House Bill 366 and some of the changes in the child support laws. One more thing that I forgot to say is one of the unintended outcomes I think that have occurred from this is that in custody cases, there's more contested custody cases. I know Howard and I were at our first training on the new child support law just about a year ago. And at that training, basically the person who was selling the child support, software basically said, come on down, everybody, file a motion to modify your child support. It'll be less, I mean, that was part of the training. And so it's clear, at least for most of my cases, that has been the outcome for the folks that we represent. So of course, it's hard for me to be 100% objective because, I'm trying to help our clients build that pathway out of poverty. So with that said, I just wanted to talk a little bit about the new law, and I think Howard's going to talk a little bit about the nuts and bolts of child support. Is that right, Howard?
Yes. You want me to do it now? Okay. Okay, before I start, I did want to say, so regarding, I know one issue that has come up and is a place of controversy is child support while people are incarcerated. And when it comes in general, as I understand it, and Ann, you may know it better than I do. In general, the person who is incarcerated can apply for a lowering of child support, that there's a program, a law in place to lower how much he or she pays. The exception that, I see most is that there is an exception. You can't lower child support if you're incarcerated for assaulting or committing domestic violence or, abusing a child who you're paying the support for, to the obligee. So you can't have beat up the obligee and then go and be incarcerated and say, I want to lower my child support. That will continue to accrue arrears. But I know in terms of people who are incarcerated for other crimes, it's I believe that most of them can't. There is a law in place to help them lower, and I know people who are working on reentry issues, and legal aid has a committee that helps with reentry, that there's a pretty broad advocacy for that, so that people's child support would not continue to accrue while they were incarcerated and build up arrears. Going now to establishing child support, usually there are two ways: through the county child support enforcement agency, although as Lon Cherie pointed out, Cuyahoga County has changed their name. It's the County Job and Family Services, Office of Children's Support Services. Okay, and what these are termed to be are called administrative actions. So now the other way is, the court hearing the custody case, and I apologize if you hear my dog because barking here. It's in the court that you either bring the divorce or you file the case in the juvenile court. That court has the jurisdiction to to establish child support. And go ahead, Chloe. And so the court and the agency will follow the same guidelines, the same worksheet that Davida was just explaining. And, in terms, so there's not a difference in that sense whether you bring it by the agency or you bring it in a court. However, if you bring an agency action and then file for a divorce, the court is going to generally or can defer to the Child Support Enforcement Agency, although you can file a motion in court to have it brought just to the divorce court. Next slide, please. Okay. So, you know, Davida gave you the broad outlines, and usually for determining custody, there are private companies that sell worksheets that you can use, and also the Ohio Job and Family Services has a website in which they have a child support calculator that you can use, that anyone can use to try to determine. So there's a legal point called deviation, in which there are 12 factors, I think it's 12, that if proven will give the court authority to either increase or decrease the result from the worksheet. It's, my cases, it's really not done a lot. It's usually they stay with what the guideline is. If you want the deviation though, you're the one that has the burden of showing why. Next slide, please. Okay, so the one difference in bringing it is that the agency does not have the authority to deviate. That's just with the courts. Next slide. Okay, so modifying. The agency will look at, oh, and just I mentioned a minute ago about the website through the Ohio Job and Family Services, and Launcherie posted the link to that website, that calculator, in the comments. So they will do it every 3 years. The agency will conduct a review every 3 years, but you know, there are statutory exceptions in 3119.60 that the person can request it earlier. And they're usually the exceptions will be a, you know, a sudden drop in income, sudden increase in income, increased expenses for the child, you know, a disability there. And I'm just wanting, in this case, I saw one of the comments about SSI. By federal law, you cannot count means tested income towards child support. So with SSI being the most common of those. Okay, next slide, please. So here are the statute for the change of circumstances in the court-ordered court-issued child support orders. You know, 10% increase, decrease, and you can read them there. But the thing is, at the bottom is that that cannot have been contemplated at the time of the order. So hypothetically, someone is on a working under contract for a set period of time. So if that is, say, a 2-year contract, and he or she is in the middle of that 2 years, well, a year later, they're going to say everyone knew the contract was ending and that his or her job income was going to change, but you didn't take it into account then. So we're not going to modify the child support. So just, again, if you have things that, you know, you got to look into the future some to see what might happen regarding all the factors. Okay, so now terminating child support. So if they are 18 and finished high school already, that's it, it's done, with one exception I'll talk about just in a minute or two. If the child is 18 and still in school, then it stays on, but no later than 19. And again, there are some other reasons having to do with emancipation, going into the military, etc., that are really beyond the scope of the presentation. Next slide, please. So generally it ends at 19. Whatever the circumstances are regarding the high school, if the kid turns 19 in high school, the child support ends. But, so this is what's called, the last bullet point is based on a case called Castle. So it's what's called a Castle child, in which before that child turns 18, if the parents know and present evidence to the court that that child will be unable to support him or herself due to a mental or physical disability, then the court can order child support beyond age 19. And, you know, if it's a severe, it usually is a severe disability regarding there, but there's been litigation that sometimes, you know, that kind of pushes it a little bit. But again, if that's the situation, you find someone that's come to you, if that's in, then really you want to certainly have them contact legal aid or somehow get in contact with an attorney, because that's an important thing. So if the child is, you know, child support will last past 18, it can go on indefinitely past 18 if that is the situation.
Thank you so much, Davida and Howard. We do have a few questions. So just to, you may have answered this, but just to make sure we touch on this point, when doing the calculations and using the calculator, or is that going to take into consideration if one parent is making a significant payment of some sort? So the example our participant asked about was tuition. Would that be built into that calculator, or does that come in with the request for a deviation from the amount that the calculator produces? And so you'd have to put evidence in about this other parent paying, you know, tuition payments as a significant contribution.
Do you want to take that? I'm going to look up the deviation factors then. Just to...
Okay. Well, I have had that come up in some of my cases before, but I think I read this question here and it says if the parties agree to it. So let's say they don't agree to it, then I think that there would be a different result. So I think that could be part of the reason for a deviation, certainly if the parties agree. But I've also seen it happen that really, actually with wealthier folks, that was their child support. They would pay the private school education, and that, you know, that was how that was handled. So it certainly is a factor that should be considered, and I don't have the deviations before me. It looks like Howard might be looking it up. But I would say that in Lake and Geauga, issues with respect to deviating from the actual figure and the child support, I would say that it happens pretty often, because I don't know if Ashtabula has changed, but out here in Lake and Geauga, a lot of the custody cases are contested, and they contest every factor, and child support and the amount of child support paid is a very significant factor.
Great.
I think with Ashtabula, of the eastern counties that we handle, it's the poorest, and the vast majority of my clients, you know, the other side is also very poor. So issues of, you know, that are you can deviate from, and that's in 3119.23, really just don't apply. They're not situations where the child is going to, you know, Grand River Academy, which is a private school out in Austinburg. those clients just don't come my way. I know with DeVita and Lake and Geauga, they're wealthier counties. So, and I think you get a lot of, if the person has come to us, and it's usually the woman, a lot of those situations, or they have a low income or no income job, and the other side has a much higher income. And then there are those kind of expenses that can come up. But just with the cases that I address in Ashtabula, the parties, just neither of them have the financial income where deviation would make much of a difference.
So then, following from that, can you just clarify the determination is based on a parent's actual earnings, or is it based on capacity?
So it just, again, oh, did you want
No,
me
go
to
ahead.
answer, Howard?
No, go ahead.
Okay. It really just depends on the facts and circumstances. I know, like when I did some committee work with the when we were actually working on the legislation, and it was surprising to some of the legislators. They didn't really believe that some folks wanted to avoid paying spousal or paying child support. They didn't seem to understand that there were parents that didn't want to pay their child support. So for that reason, and I see this a lot, like especially like business owners, so they may be in business for themselves. And so, they might actually have lived a pretty substantial lifestyle when they were together, but you can deduct a lot of your business expenses. Let's say you have a trucking company, or, you own your own truck. Then you have high expenses, and so it looks like your income is like $19,000, $20,000, and that's what you pay on your federal income tax. But actually, lived a really like $100,000 a year kind of lifestyle. So things like that actually happen to us out here in Lake and Geauga. So, or there's a person who might actually quit their job. Mm-hmm. Or maybe there was a domestic violence incident. I know this happened actually with one of my clients. The husband actually accused her of domestic violence. She actually was working in a healthcare facility, and so she lost her job as a result of being accused of domestic violence. And it was just a week or two later that the prosecutor withdrew the charges, and so she wasn't convicted of domestic violence. Nevertheless, she had lost her job, and the magistrate in that particular case actually did what's called imputing income to her. Mm-hmm. And basically imputed that she could earn what she earned previously, even though at the time the hearing was held, she had lost her job, and she had actually lost her job in, you could argue because of the false allegations that her husband had raised against her. So yeah, the court, if one of the parties thinks that the other person is artificially or understating what their income is or what their ability to earn money is, then you can make that argument. And so like if it was, for one of my clients, I would put on evidence as to what the earning capacity is of that husband or wife under the circumstances. In 2017, they earned $80,000 a year. I'd ask about what is their education, what is the job description, ask all of these things, present this evidence, and then the court would decide as to whether this person was underemployed under those circumstances, and they might impute income.
Just one thing. So it's gross income that they go off of. And again, it's much harder if you're dealing with a situation where they have their own business. That's always difficult situation factually to prove.
It is.
Let's switch gears a little bit because we have some good questions related to back support. So certainly we have seen these situations in a lot of contexts where somebody accumulates some arrearages. The child, at some point is an adult, is no longer 18, but nonetheless, there's thousands of dollars owed on back support. And so we have a couple of specific questions, but I think it would be helpful to just give a brief explanation of the difference between when back support is owed to the state versus when back support is owed to the other parent, and then the option for asking for a waiver either through the state or through the other parent of that back support.
Well, there's a lot of questions there, Anne. I'll just start with one of the purposes of child support that I actually didn't mention, but one of the purposes is to encourage the parents to support the children and not use cash assistance and other things like that. So if someone who's on cash assistance or other public benefits, applies, then automatically the child support agency is going to actually seek child support on behalf of that person. So it's important to keep that in mind. So there is money that may be owed to the child support agency, and then with adult children, there will be money that is owed to to the custodial parent. And so we don't actually do a lot of that work. I think we, when we were doing more child support clinics, we did some of that work. And if the money is owed to the former partner, the wife or the mother of the child, or vice versa, lots of times that person can waive the arrearage, and you can negotiate that kind of situation. Some of, you'd be surprised how many, former, parents who shared custody understand that their former partner had a heart attack and can no longer, pay what they were, and they're more than happy to modify that. So, that can be modify the arrearage. You can even agree to do it to zero. If I recall properly, and I think we might have some JFS folks that might be able to correct me, but if I recall, it's harder to get forgiveness for the debt that might be owed the agency. But I'd have to actually research that. We used to actually do some representation in that area. Is that what you recall too?
I would have to
We're more about getting child support in our family law unit. That's what we specialize in. But I have done a couple of cases where I assisted folks at these clinics and helped them do a motion to modify their support, or do a motion to modify the arrears. And I think that, like I said, I was able to really get a lot of cooperation from the other spouse or former spouse.
Yeah, I think on that, Lon Cherie, our colleague, just posted to a link to the statute that governs, waivers. I've not personally done any work in that area.
So I will just add, and maybe this is something I can follow up with the group of participants on, since we had a couple questions related to SSI and fixed income. There's definitely options. I am not a practitioner in this area, so I don't want to tread too far into this with giving potentially wrong advice, but certainly where somebody is now on a fixed income, like is only receiving SSI, but they are having a significant percent of their SSI taken to pay a back child support arrearage for a child who is now an adult. Our colleague, who's unfortunately not part of this panel right now, but Susan Stauffer can certainly weigh in on this for us, and I can follow up with some information, hopefully, to the group. But do know that it's worth exploring, whether it's through the waiver process with the state or whether it's an exemption through Social Security. There are some possibilities there to create some relief.
If someone's on SSD, for example, usually there are derivative benefits for the child, you know, associated with SSD, and really that person should get, you know, in a lot of the cases that I've had, they, you know, basically that's used as the child support, you know, in those kind of cases. So if there is a mistake or somebody incomes, you know, their income doesn't warrant them having such a high child support obligation, it's really important to do a motion to modify, and that can be done by the person themselves or their family member. Help them file a motion to modify based on their disability. As soon as the disability occurs, that should happen.
Mm-hmm.
You know, you need to get that filed right away so the arrearage doesn't, you know, grow.
Yeah, and on that point exactly, Davida, I'll circle back to what Howard mentioned earlier, which is that there is specifically now legislation that allows somebody who's entering a period of incarceration to modify their support obligation. They should really do it ahead of time. They need to do it right away, if at all possible, which is often the trickiest part of making these things happen. So, you know, as advocates, as support providers in our community, making sure people know they have that option and helping navigate the forms. But all of the county offices of child support services should make that form available, and they should be able to request that for the period that they are incarcerated. It certainly puts them in a better place when they get out to start without that huge debt. So I think the additional questions, let me see what this next one is. Yeah, so some complicated SSI related child support matters, which I certainly, Howard or Davida, if you have an answer there, please jump in. My hunch is that these are really particular, and I can do the follow-up I mentioned to see where we might be able to give folks some direction on these specific situations, or feel free to follow up with me directly. I'm going to put my email in the chat right now so that folks who have questions about where to go with a particular case and whether it's an issue to refer to legal aid can definitely reach out to me. I can try to offer some direction on those questions.
Yeah,
I'm just going to say that we really don't do that representation. I just sort of, I think I was volunteering, or it's when we actually had some child support clinics. Maybe it's getting to be a long time ago. It might have been 7, 9 years ago that we used to do that. But those are usually not the cases that were assigned.
All right. So we are right almost at our 12 o'clock time. If anyone has final comments or questions, feel free to jump in. We have one last question here. If a parent is given temporary emergency placement of a child, will the other parent be required to pay child support where it's an emergency temporary placement?
Well, if someone filed for emergency custody, you know, they should also file a motion for child support. It won't be automatic.
yeah.
The thing to keep in mind when you file for child support is it takes a long time, especially in COVID. You know, I filed a divorce, I think it was in July, and we still haven't had the temporary orders hearing. We haven't had it yet. You know, so if the parties don't agree and, you know, it's not an automatic thing, that child support is ordered on an ex parte basis without an evidentiary hearing out here in Lake and Geauga, usually the court will have to hold a hearing if the parties don't agree to pay support. And that it's an evidentiary hearing where both put on evidence of their income and expenses, and whether, you know, income should be imputed and all those questions we talked about before. But so then even after the order is granted, then, and let's say the person has a regular W-2 job, so a garnishment is put on their wages. It'll still, after the order is issued, it'll still take almost about 6 weeks for that person possibly to be receiving their child support. It takes a while.
And what should happen with the temporary, if you request though, say you file on December 1st, and your hearing's not going to be, because they do them about 6 weeks in Ashtabula County, you're not having a hearing until January 15th, the court can start the child support order from when you requested it. So that, you know,
Yes.
basically it'll be a little bit of an arrears that's already started, but they can go back retroactive and do it. And then, like Davida said, when so usually you send it to the Child Support Enforcement Agency, but until they start withholding from the wage, the obligor technically should be sending money to that's part of the Child Support Enforcement statewide in Columbus, Ohio, and that's always on all child support. So say you're ordered to pay $200 a month, you still owe that, and you should be sending that money to Columbus to be distributed. Otherwise, it's going to be arrears. And then say a month later, your job, they start withholding, then the wage withholding will do it.
All right.
So yeah, it can take a while for those temporary orders. So
Yeah.
you don't just file that emergency order for custody. You would also have to file a motion for child support. It wouldn't be automatic.
Davida and Howard, thank you so much for sharing all of your experiences and expertise. I think based on the feedback I'm seeing, everybody appreciates very much, has gotten some value